Alabama prosecutors are suing a deadbeat dad for child support. They kick every man off the jury except for one. The defense kicks that last one off too. The result? An all-female jury that sparks a Supreme Court case about whether your gender can get you banned from jury duty. Meet James Bowman. He's being sued for paternity and child support by the state of Alabama on behalf of Teresa Bible and her son Philip Rhett Bowman Bible. The blood tests show a 99.92% certainty that Bowman is the father. So this should be a slam dunk case. But when Alabama prosecutors want to stack their deck, they use 9 of their 10 peremptory challenges to strike male jurors, believing women will be tougher on deadbeat dads. Bowman's lawyer strikes the last man too, apparently agreeing that women won't be sympathetic to a guy avoiding child support. The all-female jury finds Bowman is the father and orders him to pay $415 a month. Case closed, right? Wrong. Bowman appeals, arguing that kicking jurors off his jury based on gender violates the Equal Protection Clause. 8 years earlier, Batson v. Kentucky said you can't exclude jurors because of race. But gender? This was still fair game in most courts. The Supreme Court rules 6-3 that gender discrimination in jury selection is just as unconstitutional as racial discrimination. Justice Blackmun writes that gender, like race, is an unconstitutional proxy for juror competence and impartiality. But Justice Scalia absolutely loses it in his dissent. He sarcastically praises the majority's inspiring demonstration of how thoroughly up-to-date and right-thinking we justices are in matters pertaining to the sexes, and dismisses their reasoning as anti-male chauvinist oratory. The bitter irony? This case happened in Scottsboro, Alabama, the same town where the infamous Scottsboro boys were convicted of rape by an all-white jury in the 1930s. Now it was the site of another landmark jury discrimination case. Bowman gets sent back for a new trial, but it's unclear if he ever got one. The bigger impact came in JEB v. Alabama, which extended civil rights protections in jury selections from race to gender. But it also marked the beginning of the end for peremptory challenges, the idea that lawyers should just get some free strikes without having to explain themselves. Today, almost any group-based exclusion can trigger a constitutional challenge. The case that started over $415 a month in child support ended up reshaping how juries are selected across America.